Hello friends, welcome to Runayas. Today we will be taking editorial analysis from the Hindu of 7th of November 2022. So I have taken this, the source is the Hindu, the topic is Uniform Civil Code. You can relate it with your General Studies paper 1, the Indian Society, population and issues associated with it. General Studies paper 2, that is the mechanism of law, mechanism and institutions for the protection and development of the vulnerable section of the society. The second topic of the syllabus would be the government policies and the issues arising out of their design and development. Now, this article is from the text and context of the Hindu, and let's proceed. What is the concept? Now, basically, if we look at the Gujarat government, recently they had constituted a committee to look into the applicability of the Uniform Civil Code. To look into the applicability of the Uniform Civil Code. All right. Now, what is this Uniform Civil Code that is in news every now and then? So, if we look at the constitutional provision of this with respect to this Uniform Civil Code, then the Article 14 Part 4 of the Indian Constitution, which is Directive Principles for the State Policy. Now, the DPSPs, that is the Directive Principles for the State Policies, are non-enforceable in the court of law. They are non-enforceable. That means for their violation, a citizen has no right to appeal to the Supreme Court or the High Court, right? So, Article 44, which is contained in the Part 4th of the Constitution, states that the state shall endeavour. Keep in mind the expression, the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. Now, the Part 4th of the Constitution outlines the directive principles of the state policy, which, while not enforceable or justiciable in a court of law, they are fundamental to the country's governance. That is Article 37 of the Indian Constitution. That means state should consider the DPSPs while formulating laws and policies for the country. All right. Now, what is this Uniform Civil Code? Basically, when it comes to the civil laws means the laws which are related with the marriage, divorce, adoption, inheritance, guardianship, etc. These are the civil laws. Civil laws, they administer or they guide the personal affair of the person or the community, right? Community as a whole and person as an individual. So the framers of the Constitution, they had envisioned. Now, if we look at India is a highly diverse country. Neither we are uniform when it comes to the language, the food, the culture, the expression, I mean the morphology. We don't look alike. There is no one race in India, although the expression race should not be used, but there is no uniform ethnicity in India. More technically and more appropriately, the term ethnicity could be used. So there is no uniform ethnicity in India. We have linguistic diversity, we have got the food and culture and the clothing diversity. We do have diversity when it comes to the customs, the traditions. We have 8.6% of the tribals as part of our population who have highly diverse customs. If we speak of the customs in the southern India, practiced by the tribals, it is very different from those tribals which the customs of the tribals being practiced in the northeastern India and in the most northern part of India. For example, the Himachal Pradesh and Uttarakhand and Sikkim. We have got regions of Punjab, and so if we look at the kingship system of India, in Indian society, you will study a little about the family and the society, the caste system, and etc. So when we speak of the kingship system in India, it is not uniform, and for sociology student, this news is also becomes of very important. So when we speak of the kingship system of India, there is no uniformity. For example, in the Punjab and in some parts of the Western India, there is no taboo with the levirate marriage, but the levirate marriage is a taboo in the Maharashtra and in some western part of the country. There is a prevalence of matriarchal system in the Khasis of Meghalaya, but matriarchal system is very rare in India. Mostly we follow the patriarchy. And when we speak of the Hindu traditions, we do follow certain provisions written either in the Mitakshara or in the, the other. So we follow two traditions. We have Mitakshara and we have the Daibhag. So the point is that still there is no uniformity. So when we speak of the uniform civil laws, so considering such a huge diversity, the uniform civil code becomes a kind of, it becomes a sort of enigma for the people, that how it would be possible to accumulate such diversity. So there are experts experts are divided on this opinion, whether there should be a uniform civil code in India or whether there should not be. Because if we consider the provisions in the Article 44, then it kinds of stand in opposition with the provisions in the Article 25 and the Article 29 and 30 of the Indian Constitution, especially the Article 25. Article 25 gives you the freedom of conscience, and conscience is not a limited term. It encompasses lot of things, especially the belief, the faith, the worship practices, the rituals, and etc. etc. So these two provisions of the Indian Constitution, they stand in opposition with each other. That one point you are giving freedom of conscience, and the other point you are basically, you are trying to accumulate everybody in the same page. On the same, you are trying to bring everybody on the same page. So considering such a huge diversity, so there is always a divided opinion of the experts whether there should be a uniform civil code or there should not be. Currently, there is no model for the uniform civil code. So there is always a confusion and there is always a conflict whenever the news with respect to the uniform civil code arises. So because we do not have a definite format, we do not have a model. Goa model is thus considered, but if we look into the depth of the Goa model, then we would see that Goa model is also contains diversity. There is no uniformity in the Goa model as well. So let's proceed and talk about what uniform civil code is, and how the government is going to have uniform civil code in India, and what the Supreme Court said in several of its judgment when it comes to the UCC. So basically, the framers of the Constitution, they had envisioned, because if we look at India, we do have the diversity, but we do have socio-economic inequality also. And if we consider the position of women, we are not at par with what has been provided to the men. So many of the rules and regulation provided in the religion, even in the Hindu Code Bill, until the 2005, the case of the Phulmati versus Prakash, the Supreme Court had called women as a co-parcener in the inheritance of the property. That was until 2025, and Hindu Code Bill was laid down in the Parliament in the 1950s, right? So there is a long gap between recognizing women as a co-parcener when it comes to inheriting the property, right? So still there is no uniformity, and still a lot has to be done when it comes to elevating the civil inequality that exists between the gender and between the several communities of India, especially women. So members of the assembly, they had stark different contrasting stance when it comes to the UCC, and some also felt that India was too a diverse country to have a uniform civil code. One of the members of the Constituent Assembly from Bengal, that is Naziruddin Ahmed, he argued that certain civil laws in all communities, they are inseparable and they're connected with the religious belief. They're connected with the religious belief and practices. He was not against the idea of UCC, but he was of the opinion that the UCC had to be an inclusive UCC which satisfied the needs and belief and faith of every community in India. He felt that UCC would come in the way of the Article 19 of the draft constitution, which is Article 25 now. This is part of the Constituent Assembly debate. So the Article 19 is Article 25 of the present constitution. Now Article 25 gives its citizen of Article 25 of the constitution give its citizens the right to freedom of conscience. And conscience is encompassing. Concise is encompassing, which guarantees the right to freedom of religion subject to public order, morality and health. Morality and health. So subjected to public order, morality and health. Now, if we look at the cases in India with respect to this public order and this health. Now, for example, the Supreme Court said that untouchability is not the essential practice in the Hindu religion, so it was held unconstitutional. For example, the instant triple talaq, it was also held as unconstitutional because it is not considered as an essential practice in Islam. Now the point is, we are not going to deep into the doctrine of the essential practice that came into existence post the Rule Mud case of 1954, but we are talking here about that the Article 25 is subjected to public order, morality and health. If there is anything in the religion that contravenes the constitution, then it has to be upheld as unconstitutional. Upheld as unconstitutional, right? Now let's move on. The member of the Indian Constituent Assembly, K.M. Munshi, he however rejected the notion that a UCC would be against the freedom of religion. Basically, India follows a secular model. So we try to keep our religion at arm's length with the state. However, Indian secular model is different from the Western secular model because the state, that is the Supreme Court, Supreme Court of course is not the part of the state, but the state, has the right to intervene into the religion when the religious practices contravenes the provisions given in the Constitution of India. So the government was allowed to make the laws covering the secular activities related to the religious practices if they are intended for the social reform. So social reform are needed. For example, the practice of sati was abolished. It was in the year 1829 that the law against the practice of sati was passed. However, the last sati in India was seen during 1970s. That was the last case of sati in India. So yes, whenever there is a requirement of social reform, the parliament can make laws even when it comes to the religious practices. So parliament does have that right. Now the chairman of the draft committee of the Constitution, drafting committee of the Constitution, Dr. B.R. Ambedkar, he had an ambivalent opinion or stance when it comes to the UCC, that is Uniform Civil Code. He felt while the Uniform Civil Code is desirable, but it should not be imposed. It should be purely voluntary in the initial stages. He stated that article merely proposed that the state shall endeavour to secure a UCC, which means it would not impose it on all citizens. See, uniformity and look alike, these are two different things. When we speak of the uniformity, that does not mean same. Uniform does not imply same. Expert says, this is not my personal opinion, expert says that there can be more than one uniform civil code, right, for one community. For example, the Hindu community can have their own uniform civil code that guides their, because still there are discrepancies existing in the Hindu code that governs their marriages, divorce, guardianship and inheritance, and there are still discrepancies when it comes to the Muslim personal laws. So still the personal laws are not codified. Even in Christians, in Buddhists and in Parsis and Muslims, the personal laws are still needs to be codified properly, so that the section of one single community is governed by one uniform code of laws, right? So this is what the opinion of the expert is. So uniformity does not mean it should be same. It should be same, right? This is not what uniformity means. Uniformity also implies the equality. So if there is a discrepancy in the practices that governs men and women differently, so that can be brought under the provision of social reform. So what are the arguments around the Uniform Civil Code? So India does have uniformity in most of the criminal cases. We have criminal procedure code, we have civil procedure code, and we have the contract act. The states have made over 100 amendments to the CRPC and as IPC. So even so in criminal laws we do have uniformity. However, the states are allowed to have minor changes and amendments in their laws. For example, the civil laws such as this law regarding the bail. So the states, they follow different bail laws. Even the bail laws are not same in India. So experts argue that in plural India, how can one nation, one law be applicable? So it is to be worked out that how the customary laws can be implemented uniformly throughout the India. For example, the consanguous marriages. Consanguous marriages are sort of a taboo in the northern part of India, but consanguous marriages are not taboo when it comes to the Muslims, when it comes to the southern India. In southern India, consanguous marriages are auspicious in nature. I mean, they are considered auspicious. They are preferred actually. This is the system of what we call as preferable marriage or preferred marriages, right? So preferred marriages are prevalent in Muslims and in the southern India, but they are considered as taboo in northern part of India. In northern part of India, levirate marriage is not taboo in Punjab, but levirate marriage is considered as taboo in Maharashtra. So the concept of marriage also is different. So if we look at the kinship system of India, it is highly diverse. The northern part, the western, the southern, and this northeastern part. So we still have different customary laws. So these customary laws, they would need it to be worked out so as to be included in the UCC. So this is going to be a Herculean task for the lawmakers then. So besides the constitutional law experts, they argue that perhaps the framers did not intend an entire uniformity. What they wanted, which is why the personal law, they are placed in the entry 5 of the concurrent list. That means both the state legislature and the parliament can make laws with respect to the personal laws. So if we look at the codified personal laws, so Hindu laws have been codified so far, although there are discrepancies when it comes to governing the men and women, but still they have been sort of codified. Although they were codified in pieces. In pieces they were codified because the conservative sections of the Hindu community, they raised voices against the Hindu code bill. So it was codified in the pieces. So if we consider that all Hindus are not governed by a homogeneous personal law, like I gave the example of the levirate marriage, I gave the example of the consanguous marriages. So how the system of marriage is different from one part of the country to the other. So even after the enactment of the Hindu code bill, there is no uniformity in the practices. Neither are the Muslims and the Christians. They are governed under their personal laws. So Hindu code bill, it did face the staunch opposition from the conservator, and then it was amended, it was diluted, and then it was watered down multiple times to finally be separated into the 4 acts, which is the Hindu Marriage Act, the Hindu Succession Act, the Hindu Minority and Guardianship Act, the Hindu Adoption and the Maintenance Act in the 1950s. And we know that in the 1956 we had one more law, that is the Special Marriage Act. So if two people from different faith, they want to get married, so under what provision they would be married? They cannot get married in the personal laws, right? They cannot get married under the personal laws. So a Special Marriage Act was created so that people who are interested, people who belong to different faith are interested into marriage, they can get married under the civil law and the Special Marriage Act, right? So do we have uniformity in the laws? Like I have argued that we still do not have the uniformity in the law, and the lawmakers it would be a Herculean task for the lawmakers to work out that how the UCC would be implemented in India, although it is desirable, so that we can uphold the equality, so that it, according to the experts and according to the constitutional lawmaker, and even according to Dr. Ambedkar, the chairman of the drafting committee, that yes, it is desirable, but it has to be purely voluntarily. It cannot be imposed on the people. And before we can talk about the UCC, we need to have a draft of UCC so that we can have a proper debate on UCC. Without a draft or without a model law, the debate is vague and it is hollow, right? So do we have uniformity? So yes, like I said, that we do have different kingships follow. For example, the polyandry, which is prevalent among the Hatti community in the Himachal Pradesh. In fact, after the news that highlighted the Uniform Civil Code, this community came into highlight that polyandry is prevalent in the Hatti community in Himachal. It's a small community in the Himachal Pradesh, and they do practice the polyandry, right? So there are different social theories with respect to the polyandry and the polygamy. That depending upon the need of the time, certain practices among the humans they do arise. We have seen cases of polyandry. We do see the cases of the cases of the polygamy. Although there is a declining trend, monogamy is more preferred these days. Serial monogamy is seen in certain cases. So let's look at the uniformity in the laws. So like I discussed the 2005 case, the Phulmati versus Prakash case, that how the Hindu Succession Act of 1956 was not uniform because it did discriminate between the men and women was not considered co-partner until this case. And in fact, in the Ashok Sharma, Mrs. Ashok Sharma versus Mr. Ashok Sharma case of 2020, Supreme Court basically had to reiterate the 2005 judgment that was given in the Phulmati versus Prakash judgment. So the wives still were not considered co-partners, and they still did not had any equal share in the inheritance. Similarly, there is no uniform applicability when it comes to the Muslim personal law, the Shariat Act that was passed in the year 1937. So it was not codified, but the Shariat Act was passed by the Parliament. So when we look at the Muslim section of our nation, the Shariat Act is not applicable in the Union Territory of Jammu and Kashmir, and the Muslims in the Union Territory, they are continued to be governed by their customary law, right? So for example, they have to register their marriage in the High Court. Like it's sort of a compulsion there, and it is in variance with the rest of the country. Supreme Court in 2019 said that Goa is a shining example of an Indian state which has a functioning UCC. However, the experts have pointed out the ground reality in the Goa is more complex than as it was seen by the Supreme Court or by the apex court of our country. So basically, the Goa Civil Court, it was given by the Portuguese in the year 1867, and it did permit a certain form of polygamy for Hindus. You see the polygamy in Hindu was also prevalent. For example, the Kuli Brahmins in Bengal, they had polygamy, and when the Hindu Code Bill was prevalent, the polygamy had to be abolished and monogamy was preferred. So there was certain conservative section of the community that rose against this provision. However, they were pacified over the period of time after the piecemeal reforms and after the Hindu Code Bill was passed in pieces, So while the Shariat Act for Muslim had been extended to Goa, with Muslims of the state being governed by the Portuguese law as well as the Shastric Hindu law. So still, there is a little diversity if we consider the ground realities of the Goa. The code gives certain concessions to the Catholic Christians. And for example, the Catholic Christian, they need not register their marriage, and the priest can dissolve their marriage also. The priest can dissolve their marriage, the marriage which is performed at the church. So Goa Civil Code was given by the Portuguese in 1867. It did permit a certain form of polygamy for Hindus, and so we discussed this part. Let's look at some of the important judgment which is with respect to the UCC. The Supreme Court in the various judgments has called for the implementation of the UCC. For example, the first important case in India was the 1985 case, which is famously known as the Shah Bano case. In its Muhammad Ahmed Khan versus Shah Bano Begum judgment of 1985, the Supreme Court said while deciding the case that had given prevalence to the CRPC, that means over the Muslim personal law. That means the maintenance the maintenance had to be provided to the divorced wife by the husband. So this was the case. The case was the maintenance case post divorce. So it did call for the implementation of the UCC. Now UCC in India, it is highlighted in the news when it comes to the women, because we know that there is a gender discrimination in India. Women are always kept a level lower than the men when it comes to the civil practices, when it comes to the divorce, when it comes to the marriages. So they are at discriminatory end. So in order to give them the equal stance, UCC, according to the experts, UCC is preferred. UCC has to be implemented in our country. So the court also called on the government to implement the UCC in the 1995 Sarla Mudgul case. Now, what was this case? What happened? Certain section of the Hindus, who wanted to practice polygamy. Now, what they did, they converted to Islam, because polygamy under the personal law is permitted in Islam. I mean, in Muslim section of the country. So they started to convert to Islam to practice polygamy. So this was the case, Sarla Mudgul judgment case. The Supreme Court said that a person cannot convert into the another faith just for the sake of marriage. Like to practice polygamy, one cannot convert, because right, this was the Sarla Mudgul case, as well as in the Paulo Cointino versus Maria Luis Valentina Pereira case of 2019. The Supreme Court reiterated the same thing with respect to the marriages. So what is the stance of the Law Commission? In 2018, Law Commission submitted a 185-page consultation paper on the reform of the family law. So basically the Law Commission called for the reform in the family law. The paper stated that a unified nation did not necessarily need to be uniform. It added that secularism could not contradict the plurality prevalent in the country. In fact, the term secularism had meaning, according to the Law Commission, only if it assured the expression of any form of difference. The Commission noted that while saying that a UCC is neither necessary nor desirable at this stage. So according to the Law Commission, we still do not have the conditions which are needed to implement the Article 44. Now, if we look at the provisions of the DPSPs, then why DPSPs were made non-enforceable or justiciable in the court of law? Because the constitution makers thought that the conditions which are needed for the implementations of the DPSPs did not exist in our country. So similarly, the Law Commission said that the conditions are still not mature for the implementation of the UCC in the country. So the report recommended that the discriminatory practices, prejudices and the stereotypes within a particular religion and its personal laws should be studied, and they have to be amended. So basically, the Law Commission called for the social reform. However, it called for the social reform, but it refrained from saying that UCC is implementable in our country. I mean, it did say that UCC cannot be implemented because the conditions are still not mature. So the Law Commission said that certain amendments would be required. For example, the marriage age of the girls, it should be uniform throughout. Currently, the marriage age is 18 and 21 for boys and 18 for girls. However, the Jaya Jaitley task force was constituted by the government to look into this matter, and it did recommend that there should be a neutral age for the marriage, that both boys and girls should be of marriageable age, that is at the age of 21 years, at the age of 21. So yes, of course, there are experts are divided on this also, that increasing the age of marriage will for the girls especially would kind of take away their freedom, because when we keep the marriage at 18, because the voting rights, if she is given the voting right at the age of 18, then why can't she marry at the age of 18? So experts are divided on this also, but we are not going to go deep into the girls' marriage age. But the Law Commission said that there can be certain social reforms when it comes to the age of marriage for the girls, and the Law Commission also said for the abolition of this concept of Hindu undivided family. Now, what is the current stance of the government? So, according to the Union Law Minister Kiran Rijiju, he said in the Parliament that this year the government currently had no plans to set up a panel to implement the UCC and request this 22nd Law Commission, which was constituted in the year 2021 of India, to undertake an examination of the various issues which are related with the Uniform Civil Code. Right. So this was all about the Uniform Civil Code that we had discussed. We discussed the several important judgment of the Supreme Court with respect to this. We did discuss what Uniform Civil Code is, and we also discussed the diversity of our country and the non-uniformity when it comes to the personal laws. When it comes to the, we did see certain examples of the kinship system and the practices of the kinships that is prevalent in our country, and how the government is at present is not interested in setting up any panel with respect to the UCC. So that was it for today. Thank you so much for watching Tarun Eyes. Have a nice day.